name. Balsamo, can someone please tell me how she relates to the proceeding? I don't see her on the notice.
I'm not sure.
Okay.
I believe she's an interested party. I think she is a current or recent owner at Pelican Isle.
All right, well, this is Judge Krier. Anybody that's not actually a party or a party or someone that's trying to be a party needs to view this on YouTube and not be a part of these proceedings. So, Ms. Balsamo, if you would like to view these proceedings, you're more than welcome to do that on YouTube. All right, it is 9:59. This hearing is set for 10 o'clock. It is case number 18CA 3395. It's the residences at Pelican Isle versus American Coastal Insurance Company. And we're here for a number of hearings. So if everybody would identify themselves for the plaintiff.
Good morning, Your Honor. Matt Weaver on behalf of the plaintiff.
All right, and for defendant American Coastal.
Morning, Your Honor. It's Bill Burke and Melissa Sims for American Coastal Insurance Company.
All right, and
yeah, we have somebody by phone and they won't identify themselves.
okay. Well, it looks like they got
They hung up. Okay.
but we are waiting for, aren't we waiting for the attorney representing the umpire?
I believe so, Your Honor. That would be Mr. Haar.
Yeah. Because he has a motion that's scheduled for today. Well, we can do your other motions first.
Happy to do that.
So what I have scheduled for today is Pelican Isle's motion to dismiss the amended counterclaim that was filed, or not, the motion was filed on April 29th, 2021. I have Pelican Isle's motion to strike American Coastal's second amended affirmative defenses. The motion was filed on April 29th. And I have Pelican Isle's renewed motion for judicial notice, which was also filed on April 29th. Then I also have American Coastal's motion to stay payment of the umpire fee, and then the umpire's motion to intervene. Mr. Haar, are you here representing?
I am representing Sam Woodward on the motion to intervene.
Okay, good. Actually, I wanted to do that one first, so I'm glad you're here. All right, so, and if you want American Coastal, we can deal with your motion to stay payment at some point too.
Yes.
Okay, so Mr. Haar, this is your motion. Go ahead.
Your Honor, I think if I may, we do not have an objection to the motion to intervene.
Okay.
The notice, so I don't want to have him.
Okay, that's great. Mr. Weaver, do you have an objection?
No, Your Honor.
Okay. Well, my understanding after reviewing the file as well as some of the case law is that what's required here is the court needs to provide in the order, and I don't know that you guys have agreed to this yet, exactly the parameters of the intervention. So what I would be providing in a ruling would be that this is limited to Mr. Woodward's fees. I can't think of anything else he'd be involved in. Does everybody agree with that, Mr. Haar?
I'm in agreement with that. The only thing we're seeking is payment of Mr. Woodward's umpire fee from the defendant American Coastal, and
Okay.
the intervention would be limited to that issue only.
Okay, and then I also needed to give you a specific period of time in which to file your pleading. How much time do you need?
20 to 30 days at the most.
Okay, so I'll give you 20 days to file, and then everybody else has got the normal amount of time to respond or file something in connection with that. All right, so Mr. Haar, I'm going to need you to prepare an order after you've circulated it, forwarded to my office email address in Word format. All right,
Okay.
Ms. Sims or Mr. Burke, would you like me to address your motion to stay now or later?
I think it makes sense to entertain it after their pleading is filed.
Okay, so you don't want me to address your motion to stay now?
Well, I don't, well, if without the pleading, I mean, I can, the reason, we can
You
address,
guys filed it, noticed it. I mean, somebody noticed it, so.
we did.
But it's your motion. If you don't want me to address it now, that's fine too.
Well, I mean, I get, there is no order for payment now. I'm just saying it seems to make procedural sense that it would be in response to the pleading. We filed it, noticed it because we weren't aware of, how it was going to proceed.
Okay,
So
that's
I-
fine.
that makes
So we'll
sense.
just, we'll postpone that hearing.
Yes.
Can I ask how Sam relates to the proceeding?
I'm sorry, what? Oh, so we have somebody else that just came on. The court report is just trying to keep track of people. Sir, that just came on, Sam, who are you? Who is this person? If you are not a party, you are welcome to, I can't hear you. You're welcome to watch the proceedings on YouTube, but you can't be in this hearing.
I'm the umpire of record, ma'am.
Oh, okay. Well, I didn't recognize you. Okay, so yes, you are now a party, so you welcome. If you want to hang around for the remaining of the proceedings, you can. Thanks.
Can we get the last name?
It's
Woodard,
Go ahead.
Woodard.
all right. And Madam Clerk, if you would just reflect that American Coastal's motion to stay is going to be rescheduled. And if you want to file that in a different format, I'll also give you leave to amend it, so you've got time to do it. All right, so now we're moving on to Pelican Isle's motion to dismiss, and motion to strike, and motion for judicial notice.
I don't want to interfere, but you want me to put that in the proposed order that the motion to stay is to be rescheduled? So there's the record of that?
Yes.
Thank
That'd
you.
be great, Mr. Hart. Thank you.
Have a good morning.
All right, you too. You're welcome to stay since you're now technically a party, but you don't have to, so up to you.
I don't believe these motions really pertain to the payment of the umpire fee, so I am gonna do something else with all due respect.
All right, thank you.
Thank
All right,
you.
Mr. Weaver, let me just tell you what my first impression is, so you may or may not want to address this, is that some of what you're alleging in your motion to dismiss seemed more appropriate for a motion for summary judgment, as well as that was my thought about the judicial notice also. So
Understood.
you can choose to address it or not, but
Understood.
that was one of my questions.
Okay. I think if Your Honor recalls the prior hearing on these issues, much of the argument is extremely familiar and similar to what was argued before. That's mainly a function of the similarity of the pleadings that have been filed by American Coastal. I'll start, if it pleases the court, by just framing the pleadings as they currently sit. So we have.
Can I ask you one question? I'm sorry to interrupt you.
Certainly.
I just want to make sure that I have looked at the appropriate pleadings. The operative complaint that you guys filed was filed on November 5th, 2018, correct?
That is correct.
Okay, and that was a one-count complaint for declaratory judgment to compel the appraisal, correct?
Correct. And in part of the relief requested was that the court reserve jurisdiction to enter orders that might be necessary related to the appraisal, including judgment on the eventual award.
I understand.
That's essentially where we are from the plaintiff's perspective.
I understand. I just want to make sure. And then also, I also want to make sure that I'm looking at the correct answer. Hold on. The answer that I was looking at was filed, well, the counterclaim was filed on April 19th, 2021. And the affirmative defenses that I think are operative or was filed then also. So is that the correct one, Ms. Sims or Mr. Burke?
Yes, Your Honor.
Okay, good deal. All right, go ahead, Mr. Weaver.
Certainly, Your Honor, and may it please the court, just to sort of reframe where we are. As Your Honor noted, we're here on motions to dismiss and motions to strike and request for judicial notice. Essentially what has happened here is American Coastal has tightened up their pleadings in terms of eliminating certain affirmative defenses, and also before there were 2 counts in the counterclaim, now there's only 1 for declaratory relief. But that count for declaratory relief is substantively unchanged from the count for declaratory relief this court dismissed without prejudice earlier this year. If you take a look at the counterclaim, again, the thrust of it appears to be what American Coastal pled and alleged before. The allegations are essentially this: Pelican Isle's appraiser and the court-appointed umpire allegedly have an indirect financial incentive to increase the amount of any appraisal award due a Pelican Isle because of an alleged relationship, not with Pelican Isle, but with the public adjuster hired by Pelican Isle Keys Claims Consultants. The relief sought here is also important, and it's something we discussed in the hearing that we had before Your Honor previously on these issues. According to American Coastal, these allegations lead to essentially corruption of the appraisal process, and the declaratory judgment sought is essentially along three grounds. One, the award itself is invalid and has to be thrown out, and the Pelican can't recover anything further. It's that last ground that is extremely, extremely rare. No court in Florida law has sanctioned that type of relief. The counterclaim also includes references to what happened in the appraisal itself, what evidence was considered or not, what the umpire did or didn't do. Again, nothing about a direct financial relationship with the insured, either by the appraiser, Mr. Middleton, or by the umpire, Mr. Woodard. The first affirmative defense mirrors, in large part, the allegations of the counterclaim. It focuses on
and I didn't see, but maybe I missed it. I also didn't see any allegations that either your appraiser or the umpire had any financial arrangement with the public adjuster.
Correct. Essentially, the allegation is that there's an incentive, really an indirect financial incentive to increase the amount of any award, both on behalf of the appraiser and on behalf of the umpire.
Right, so they're alleging, as I understand the counterclaim, and maybe they'll also clarify this too, is that the appraiser and or the umpire had a relationship with the public adjuster, who we disqualified as your appraiser, and they had some sort of a relationship. But more than that, they had a financial relationship, meaning that they're going to get some money from the public adjuster based on their determination.
Yeah,
I didn't see that last part in the.
And I agree with that. Those allegations don't exist, and I think for good reason.
Okay, go ahead.
So, again, the first affirmative defense mirrors largely the counterclaim. There's also this notion that's sprinkled in the first affirmative defense about Keys Claims Consultants being an assignee of Pelican Isle. We've talked about this issue before. It's simply wrong. American Coastal knows it's wrong. They've known it for a really long time.
Okay, but why are we addressing this in a motion to dismiss?
That was my next point, Your Honor. I don't think it's relevant to the motion to dismiss.
Yeah.
And I don't think it helps really American Coastal's pleading. And then we have the second affirmative defense, which is the fraud
motion to strike. I'm sorry. Go ahead.
Correct. Right. We have the second affirmative defense, which raises the fraud issue. Now, there are allegations essentially identical to the ones that were stricken and dismissed before about inflating the claim. There are also some sort of, I would call them random statements that are also appearing in the counterclaim about what happened in the appraisal. There's no connection between those allegations and any type of fraud or misstatement by Pelican Isle. Then we have the third affirmative defense, which raises an exclusion under the policy that deals with exterior waterproofing. And as we'll discuss later, that there's no way that American Coastal can state a claim for relief under that language, because the appraisal award squarely falls within an exception to that exclusion.
Okay, but here's the problem, though, is that you're asking me on a motion to dismiss to take in evidence. That's what the notice of judicial, the motion for judicial notice is. And that's just, I mean, there's only a few very limited circumstances where courts do that, and most of them are regarding personal jurisdiction. So again, I just don't understand. I mean, sure, they can allege whatever they want to allege in their pleading and their affirmative defense. You may disagree that it's true, but that's what a trial and or a motion for summary judgment is for.
So I think there are a couple issues there. One, on the third affirmative defense, it's a failure to state a claim argument. In other words,
Okay.
there's no facts alleged or that could be alleged that would allow American Coastal to state that claim. On the second affirmative defense, and I think the request for judicial notice only relates
Well, they do
to the
allege,
fraud issue.
I'm sorry, in the third affirmative defense, they list the exclusions, okay? And then they say, pursuant to the inspection of the property is alleged to have suffered damage to exterior paint. Now, you don't have to allege every single fact that forms the basis of your affirmative defense, but that's enough. Now, what you're telling me is that's not true. Well, that's a subject for a motion for summary judgment.
I think what I'm saying, Your Honor, is that their allegations omit the second part of the exclusion, which is an exception that essentially says if other parts of the building are damaged by a windstorm, this exclusion doesn't apply. So they haven't alleged those facts, and they can't because they know it's not true. Candidly, that issue, the issue of the third affirmative defense, is probably one that is, we don't want the tail to wag the dog here. That's a relatively minor issue in the grand scheme of this case compared to the other issues.
Yep, okay.
So I want to start with, again, something that Your Honor is well familiar with by now, and that's the partiality and corrupt process allegations that form really the heart of the counterclaim and the first affirmative defense. If Your Honor recalls, recently, in the context of discovery in this case, Your Honor ruled that in order for or the relevant inquiry and discovery was essentially whether there was a direct financial relationship between Pelican and its appraiser, or Pelican and the umpire. No type of direct financial relationship is alleged in this counterclaim or the first affirmative defense. Again, the allegations essentially are, and the counterclaim is a little bit hard to follow, just like the first counterclaim was, and it references other insureds that are not Pelican Isle. But trying to give American Coastal the benefit of the doubt, the allegations are that Sam Woodard was not an impartial umpire because he has this indirect financial incentive in the outcome. Same with Mr. Middleton, and that the process was corrupt based upon the actions of the two of them during appraisal. Again, and we've discussed this before, American Coastal is limited in the challenges it can raise post-appraisal. No Florida court has ever recognized challenges along the lines of what American Coastal alleges regarding the conduct of the appraisal process, namely what evidence was considered, what evidence was not considered by the umpire, the presentation of things like a civil remedy notice. There are multiple courts that have said that's not the type of thing that we're going to look into when it comes to a challenge to an appraisal board. Again, the issue with Woodard's partiality or alleged partiality. The policy language that American Coastal drafted and sold to Pelican Isle doesn't require Mr. Woodard to be impartial. There is a Florida statute that we've talked about before, section 627-70151, which does set forth certain grounds by which an umpire can be disqualified. Those are, again, not alleged here. One of them is a familial relationship with the party. Another is prior representation by the umpire in a professional capacity, either in the same claim or in another matter involving one of the parties, or employment by the umpire by a party within the last 5 years. None of those things are alleged. So we're down to Mr. Middleton. Again, the allegation is that he's partial because he has some type of relationship with Keys Claims Consultants. No Florida court has ever found that that is enough to disqualify an appraiser. If you take a look at the cases, and I know Your Honor has read some of these, there are essentially two groups of grounds. One is a direct financial stake in the outcome. We have plenty of cases now after Hurricane Irma that deal with public adjusters and contingent fees, and that's of course what Your Honor ruled in this case with respect to Mr. Keys. That would be disqualifying under those cases. And again, that issue is up at the Florida Supreme Court as we speak in the Sanders case. And the nature of the appraiser's relationship with the party appointing him. So we have a series of cases where an insured building consultant was allowed to proceed as an appraiser in the Brickell Harbor case. We have the attorney for the insured in the Bronco case, and we have an expert for a party in the Vernius case. These are all direct relationships with a party, and none of those types of relationships are alleged as it relates to Mr. Middleton. Again, we can take a stroll through the cases, and there are several that are important. Brickell Harbor is a very important case. The challenge there was, again, to a building consultant hired by the insurer. The insured challenged the partiality of that building consultant. The third DCA said that's not enough. That particular building consultant is an employee of a company hired by the insurance company. He does not have a direct financial stake in the outcome. His pay is not going to go up. He's not going to get more money out of the appraisal if he sides for one side or the other. Third DCA said that's not enough. Again, we talked about this before. Judge Kuntz's concurrence in the Valenti case from the fourth DCA is extremely important, I believe. Again, that case talks about a contingency fee relationship between the public adjuster and the insured as being disqualifying, but Judge Kuntz draws a distinction between that type of direct financial relationship and cases involving a prior relationship with the parties, suggesting that the direct financial relationship is disqualifying, but the prior relationship isn't. He also cites with approval out-of-state cases that describe and allow appraisers to act as advocates for the party who hires them. No Florida court has ever found that an appraiser cannot act as an advocate for the party who hires them. That allegation is sprinkled throughout the pleadings by American Coastal here. Again, in American Coastal's papers in response to this motion and at the hearing on the last motion, they cite a series of cases, and I want to talk about these cases briefly. The first is the Winger case from the fourth DCA. This case is from 1993. This is an allegation where an umpire was alleged to have a prior relationship, again, with a party, something that courts have found disqualifying before. Here, the umpire had been hired by the insurance company previously, and during the relevant time period where the appraisal was going on, was being paid by the insurance company on other matters. The court essentially held that that relationship should have been disclosed, and the relief, and again, this is important, the relief is very important here. The relief was only to vacate the award, not to say that the insured couldn't recover, not to say that there was any further prejudice to any of the parties, basically starting the appraisal process over. One of the things I think in Winger that the court got wrong, and there was no way for the court to know this back then, but 9 years later in 2002, the Florida Supreme Court decided an opinion called Alvarez, which essentially held that appraisal clauses are not arbitration provisions, and the court in Winger essentially treats them as the same. So we don't think Winger applies or would even supply the rule of decision here. There's another case that American Coastal cites called Alvarez. This is a much newer case from the third DCA, 2019 case. This case is just fairly unremarkable. It's a situation where a jury decided issues of misrepresentation and fraud, and there was an inconsistent verdict. The jury essentially found that the insured had misrepresented some material fact about their claim, but they also awarded the insured damages. And the court essentially said, well, one, the misrepresentation provision was enforceable, and the insured did not preserve the inconsistent verdict issue on appeal. So the judgment was affirmed. It's interesting, if you look at that case, the case actually quotes the jury instructions that were given in the trial. One of the jury instructions that was given in the trial was that overestimates of value are not fraud, which is something we've been saying in this case now for several years. The other case that American Coastal relies on and relied on in the last hearing is the Romanok case again from the third DCA. This is a 2017 case. This is a case where the carrier in a declaratory action raised an issue regarding the professional and familial relationships between the insured's appraiser, the umpire, and the water mitigation company hired by the insured. Again, read this case closely. The relief sought by the insurer in that case was only for a new appraisal, not to completely shut the insured out of recovery. So also in that case, the policy language required that the umpire be impartial. American Coastal didn't draft its policy that way. So you're dealing with a different dynamic in that case. The court also expressed no opinion on the merits as to the impartiality question. So there's another issue raised in the counterclaim that we've addressed in our motion, and this is that the issue of post-loss condition compliance. Now, it's not entirely clear from my reading of the counterclaim if this is actually a separate ground for relief by American Coastal. They mention it, they allege it, but they don't really hit it in their actual count for declaratory relief. But giving them the benefit of the doubt, this is an issue that is really controlled by the law of the case. All of these issues were raised in response to the motion for summary judgment, partial summary judgment that was filed 2 years ago that Your Honor granted in sending the case to appraisal. The same issues were raised on appeal at the second DCA. The second DCA rejected them as well. So there's no reason to give American Coastal another bite at the apple on these issues. They've already been adjudicated. Even if that weren't the case, excuse me, the issues fail on the merits. There's no allegation that American Coastal was prejudiced by any of these alleged issues of noncompliance. There's no allegation that the breaches were material. Both are required under Florida law. The issue of an examination under oath of moisture intrusion solutions, again, this was argued on appeal to the second DCA. Excuse me. The policy doesn't allow American Coastal to take an EU oath of moisture intrusion solutions. It only allows examinations under oath of the insured, the public adjuster, or an agent or representative of the insured. Moisture intrusion solutions is just a company hired to do water testing on the building after the storm. They're not an agent of any of the parties. They're not a representative of Pelican Isle. So this is not something that American Coastal would be allowed to do in any event. The other issue with their request is that it was made after the lawsuit was filed. Again, there are cases, and we cite them in our papers, including the Willis case and the Fleurimond case, that say if an insurance company requests post-loss condition compliance for the first time when the insured is in suit, that's not a valid reason to prevent contract performance. Moving to the issue of fraud, and this is really the second affirmative defense. Again, we've argued this now, I think, in 4 separate hearings, so I don't want to belabor it too much. A couple procedural points. This issue keeps evolving in terms of what the allegations are. Before the summary judgment hearing 2 years ago, the allegation was simply stated in a denial letter. In other words, the claim was denied on the basis that Pelican Isle had misrepresented the amount of loss. After summary judgment was granted, Pelican Isle moved to amend its affirmative defenses. The case was on appeal, and not Pelican Isle, American Coastal moved to amend its affirmative defenses. That motion was never actually set for hearing. I believe it still has not been set for hearing. And I guess you can consider those particular defenses abandoned, considering where we are today. But there's no dispute that the amount of Pelican Isle's loss has been set by the appraisal panel, and that it exceeds the preliminary proof of loss amount that forms the basis for this allegation that the amount of loss has been misrepresented. And this ties in to our request for judicial notice. We ask for the court to take judicial notice of a couple things relating to the appraisal award. Its amount, what it says, what it finds, and the fact that it was signed. None of those issues are in dispute. American Coastal has not pled them anywhere for reasons that you can only imagine would be strategic, but the award is referred to by American Coastal in its pleadings throughout.
Well, since the award as policy, as is the case with policies, when you refer to it in a pleading, I can take consideration of the entire document, so.
Right. So again, for the judicial notice issue,
as long as I'm not using it for the truth of the underlying substantive matters, then that's, but we'll see. Go ahead.
Understood. So the argument against taking judicial notice of the award by American Coastal is essentially that there's another version of the award that's unsigned. We don't dispute that, but that's also not a reason to question the accuracy of the document we ask that the court take judicial notice of.
Where does that say that? I didn't see that.
It's in their response.
Their response to the motion. Okay.
Yeah, they may not suggest that judicial notice be taken of that, but they're essentially saying you can't rely on the accuracy of the document we ask the court take judicial notice of because there's this other document. Well, that's a non sequitur. That doesn't really question the accuracy of what we ask the court to take judicial notice of. Again, tying that back to the fraud issues, American Coastal has admitted in its pleadings that the policy was in force and effect at all relevant times. That's a fatal admission to its attempt to avoid coverage here. Again, the law about overestimates of value not being fraud is well entrenched. We cite the cases in our papers. To the extent that the fraud claim is based on something else, it's still not pled with particularity. If you take a look at the second affirmative defense, I'm going to read it. The only thing that relates to the amount of loss is this. By claiming that every single window and door at the property was damaged by Hurricane Irma and required replacement, plaintiff, through its representative KCC, grossly and intentionally inflated its claim. That's still not sufficient under Rule 1.120B. You've got to have more than that. If you take a look at what's alleged in the counterclaim, you've got similar allegations. Frankly, these allegations haven't changed. This is the same thing that American Coastal alleged in its first counterclaim. And I'm going to read it again. Based on the facts that have been discovered during its investigation, it became apparent that plaintiff made misrepresentations of material facts and concealed material facts as plaintiff's claim was grossly inflated and its appraiser was not impartial as required by the policy of insurance. There's no explanation as to how the impartiality issue ties into misrepresentation. It's completely just a non sequitur, but that allegation hasn't substantively changed. What was discovered, what is concealed is not alleged. Again, what this court did the first time we dealt with this issue and sending the case to appraisal has essentially now been blessed by the second DCA, and the issue is going to go up to the Florida Supreme Court to decide. But if you take a look, I know your Honor's familiar with these cases, take a look at what the court said in Leeward Bay and recently the Bellagio case, which came out, I think, a week or so before we filed our motion. American Coastal cites it in their papers. This is what the court said about having appraisal come before the coverage issues or the fraud issues. They said it's not only judicially efficient, but may be necessary where the findings in the appraisal are interconnected to the trial court's finding of liability. That's exactly what happened here. I mean, you have a carrier, after an appraisal award is entered for more than the amount of the claim, saying that the claim was grossly inflated. American Coastal has yet to explain how that's even physically possible. So we ask that the second affirmative defense and any issues in the counterclaim dealing with fraud be dismissed and stricken. And we've already briefly touched on the third affirmative defense.
And just to be clear, we're talking about their allegation of fraud about the windows and doors, correct?
That's the only allegation of, taking what they're saying is true. And I don't think that they've pled that with particularity, but there's no connection between any other allegations in the pleadings and fraud. I mean, they try to connect the issue of appraisal and Mr. Middleton's impartiality or partiality to fraud, but that's not explained. So again, I don't think you can actually fairly say that they've made those allegations. Again, on the third affirmative defense, we talked about this. It's really a failure to state a claim argument. To the extent that American Coastal is saying that this waterproofing exclusion applies. It's clear on the face of the exclusion that it does not apply, because there's no dispute that, well, one, they haven't pled it, first of all. They haven't pled around that. But taking that.
Well, they haven't pled it the way you want it pled, but they have pled it.
Right. They can't state a claim under it because of the exception to the exclusion. That's the point. So again, I want to circle back to the remedy and the next steps. So one of the allegations, or one of the arguments that American Coastal makes in its response, and this is not a new argument, is that somehow Pelican Isle is stopped or prevented from even challenging what American Coastal is doing. And they cite to the Mango Hill case for this, and they've cited to it before. At no time has Pelican Isle ever argued that American Coastal cannot raise a defense to the appraisal award, but those defenses have to be legally valid. Cases like Mango Hill don't give a carrier carte blanche to raise legally invalid defenses to the entry of judgment on an award. That's the argument. So we contend that at this stage, the appropriate remedy is dismissal with prejudice. The allegations have not substantively changed. I'd suggest to Your Honor, they may have gotten even more convoluted based upon the attempts to tie the appraisal process into the fraud issue. And this court has already found, for purposes of discovery, that the relevant inquiry is whether Middleton or Woodard have a direct financial relationship with Pelican beyond being paid by the hour for their work in the appraisal, which is what the policy allows. American Coastal can't plead facts to fall within that paradigm because there are none. So we'd ask that dismissal in this case be with prejudice. Thank you, Your Honor.
All right, who's responding?
That would be me, Your Honor.
All right, go ahead.
Good morning.
And also, at some point, if you could also address my review of your counterclaim and affirmative defenses reflects very little, if any, allegations about a direct financial relationship between the appraiser and the umpire and Keys. I think I found something in there that looked a little bit like that. You said in paragraph 33 of your counterclaim, the exact amount of fees derived by KCC and Middleton from this undisclosed relationship is presently unknown, but believed to be substantial and should be revealed through discovery. And that's the only thing that I found in there that even hinted at some type of financial benefit to Mr. Middleton, the appraiser. But perhaps you can point something out that I missed. So anyways.
No, thank you for pointing that out, Judge. And we do allege that, and we do want to take discovery to get that sort of information. As you are well aware, that's not a matter of public record. What we have been able to find, and which we've pled, are the multiple cases where Mr. Keys and Mr. Middleton have worked together.
Okay, and one thing I should also just caution you about, just so that nobody gets themselves into trouble, is that I distinctly remember being at a hearing at which you all agreed on Mr. Middleton, and it was stated at that hearing by plaintiff's attorney that the public adjuster had recommended the appraiser that the plaintiff was willing to hire. And I distinctly remember defense counsel saying, we agree to that. So, I mean, again, I realize now you don't like it, but just be careful about what you're representing to the court, because that was mentioned. It was not hidden at the time that the Mr. Middleton had been recommended by the public adjuster.
Well, thank you, Your Honor. I personally wasn't at that hearing, but I'm not running away from the hearing either.
Yeah.
There was a disclosure that was made by Mr. Middleton, and we've alleged the disclosure was inaccurate. The mayor recommend, and I would say that I'm sure Your Honor's recollection is correct, and I would not argue that the mayor recommendation by the public adjuster of Mr. Middleton would be sufficient to call into question Mr. Middleton's impartiality. So agreeing that that statement was made and agreeing that we agreed at the time does not at all undercut the case that we have based on what we have since discovered. But let me begin at the beginning, and I'll try to address Mr. Weaver's arguments as well as the court's question. And I was going to say when I was planning the argument that context is everything, and I was very happy to hear that the court actually started with the exact context that I was going to bring up. The context here is we have competing declaratory judgment actions. The plaintiff brought an action, as you know, to compel appraisal and for ancillary relief, including the entry of a judgment. They did not sue for breach of contract. Since that time, some courts have questioned whether that's proper, but that horse long left the barn. Whether that was proper or not is beyond what we're here to argue today. But they've got a deck action in which they're essentially asking the court to enter a judgment against my client without a breach of contract. So what we've done is we've raised affirmative defenses to payment, essentially 2 affirmative defenses to payment, and what I'll call a mirror image declaratory action to have the court make a declaration based upon any factual findings that might arise from the disposition of those 2 affirmative defenses. And I want to clarify something. We're not proceeding as an affirmative defense on the failure to submit to an examination under oath. And that's not, I don't think that's pled in the latest iteration of our pleading. Our 2 affirmative defenses are, well, I'll get to that in a second. So basically at the time of the court's disposition of the summary judgment motion, partial summary judgment motion, American Coastal had raised fraud or misrepresentation by exaggeration and post-loss conditions as defenses. We're not proceeding on the latter, but American Coastal believes that the appraisal process itself was corrupted in the manner that we've pled. And so we're proceeding on defenses by way of affirmative defense for misrepresentation and also based upon the appraisal process. As the court has noted, and I want to reiterate that, you did disqualify Mr. Keys as an appraiser.
Right.
The plaintiff in their papers accused me of being disingenuous by stating, and I've repeated this many times, that Mr. Keys has an assignment. I'm merely stating what his contract says. His contract says that the owner agrees to pay to KCC in consideration thereof and hereby assign to KCC a contingent fee of 10% of all insurance funds, contractual and extra contractual. So the contract actually uses the term assign. And without going too far afield in the case law, there's a long history to that language in a public adjuster contract going back to the Saracen case from 20 or 30 years ago, which actually gives a public adjuster a right to bring a direct action against an insurer when he or she or it is not protected on payment. So it's not an accident that that contract includes the word assign. So Mr. Keys took an assignment of the claim, which makes him a direct stakeholder. Now, of course, the court entered this partial summary judgment on their request for appraisal. And of course, the second district affirmed it, but noted that American Coastal was not foreclosed from challenging coverage. And the second district later, I think, refined what it meant by that in the Leeward Bay and the Villaggio at Estero cases, because in both those cases, the insurer raised the exact defense that American Coastal is raising here. That is to say, in both those cases, American Capital, the insurer, raised misrepresentation and fraud by exaggeration of the claim or gross exaggeration of the claim. Let me step to the shoulder of the road for a minute and address an issue that has been repeatedly stated to Your Honor by the plaintiff, and I think they're just simply incorrect. The case law doesn't support it. What they've said to Your Honor is that an exaggeration of a claim is not fraud. I'm trying to find the exact words they've used. They use.
Well, I'm familiar with this allegation. So, I mean,
Yeah,
on both sides.
Yeah,
Both sides.
Oh, no, what they're saying is overstatement is not fraud. And, you know, we agree with that. That's beside the point, because, you know, an innocent overstatement, an innocent.
Well, first of all, that's an issue of fact, and I'd have to determine that you're allowed to allege that.
Exactly.
So far, I haven't had any, but that's the smallest allegation in this counterclaim and affirmative defenses. If that's really what we're talking about, that would be easy to decide, because you're allowed to make that allegation, and then we either decide that on summary judgment or at a trial.
Okay, I totally agree, but
that's the smallest part of your allegations.
Well, yes and no. I mean, I think
No, I think that's the smallest, because most of your allegations have to do with all this convoluted allegations about the public adjuster, the appraiser, and the umpire.
I'm not sure that I would say they're convoluted, but I will defer to the court's the court's reading of them. But these are actually two separate and distinct affirmative defenses.
Yes.
And I think they need to be understood as such. You know, the plaintiff counter defendant wants our case dismissed with prejudice. Leeward Bay, Villagio, I think this case on appeal gives us an absolute right to proceed on the exaggerated claim affirmative defense. And the second affirmative defense that we're proceeding on, and again, this is mirrored in the deck action, goes with what we would say would be the corruption of the appraisal process, that neither the appraiser nor the umpire were competent and impartial. Now, it's been repeatedly said by many people that there has to be a direct financial interest. The plaintiff in this case, the counter defendant plaintiff, has been advocating the Brickell Harbor case repeatedly. Well, Brickell Harbor actually refers to both a direct or indirect financial interest. Brickell Harbor states an appraiser's direct or indirect financial interest in the outcome of, and it used the term arbitration, including, but it didn't say including, but limited to. It said an appraiser's direct or indirect financial interest in the outcome of the arbitration, including an arrangement for a contingent fee, requires disclosure rather than disqualification in the case of an appraiser. So what happened there is they said there wasn't a full disclosure, but they also referred to an indirect financial relationship. And that's the case that's been relied on by the plaintiff. That's the Brickell Harbor case. Now, we're always candid with the court, and I'll tell you that even though the plaintiff in this case has been relying on Brickell Harbor, the second district did not find Brickell Harbor's analysis persuasive. Remember, this is the case that's in conflict with other cases before the Florida Supreme Court. What the second district said is, we do not find Brickell's analysis persuasive. We certify conflict with Brickell to the extent it holds that a public adjuster who has a contingency interest in an insured's appraisal award or represents an insured in an appraisal process could serve as a disinterested appraiser under a policy's appraisal provision. So they didn't disagree with Brickell in its entirety, but they did disagree with the result, because in Brickell they did not disqualify somebody that had a contingent fee interest. So they took a very different view in your court, in the second district. But the important point is that Brickell does refer to an indirect financial interest, as does the Wenger case. The plaintiff refers to the Wenger case as a case from 20 or 30 years ago. It's still good law. It doesn't matter that it is an older case, because it stands for just a very basic proposition that the umpire cannot be corrupt. And in Wenger, contrary to what was argued by my colleague earlier today, the umpire there did not have an ongoing relationship with State Farm in that particular case. The court was relying upon an indirect financial interest that Mr. Whidden, who was the umpire, had with State Farm, because what they talked about in that case was that he had collected revenues from State Farm from 1987 to 1990. This case was in 93. And he testified that he didn't know how much he had for that particular year. So there was no evidence that he was still working for State Farm as a consulting expert, nor that he had a direct financial interest. It was the indirect financial interest that Mr. Whidden had that was not disclosed, like here, that caused him to be disqualified. And again, I want to bring up something else that I think has been somewhat misleading in the argument. In our prayer for relief in the declaratory action, we've asked that the court declare that the award be invalid due to the corruption of the process, and that the award be vacated or set aside. And we've also asked that the insured declare that the court breached the insurance policy and not entitled to recovery. Remember, we have the two separate affirmative defenses, and the fraud defense would require a finding in favor of American Coastal. I'm a little unclear whether the appraisal process would require a judgment in favor of American Coastal. I guess maybe.
Oh, I think that's very clear. If you guys win in that, you're just going back to appraisal.
I think that's not true, Judge, because
Well, you and I disagree then, because I can tell you right now, I've researched this, and that's what I think it means.
well, you are.
And I haven't seen anything that tells me differently.
Well, you're the boss for sure, and I'm not suggesting anything other than that. However, there is a case from Colorado, and I mentioned this briefly, where the chief judge of the district court there found that there was either willful ignorance or complicity by the insured under similar circumstances, not coincidentally involving Mr. Keys, and under those circumstances did not allow for a do-over. So, and that was affirmed by the Court of Appeal. So what I would only suggest to Your Honor is that depending upon the facts that are come out in discovery, if there is willful blindness or complicity on the part of the insured, then there might be a different remedy than if not. So I think it's putting the cart before the horse. So I'm not disagreeing with Your Honor, but I do think there are circumstances where that might be the remedy, but it's certainly the remedy if we prove that it's a fraudulently or grossly exaggerated claim or there are material misrepresentations.
Yeah, I understand the distinction.
Okay, so I mean, that's all I'm saying. I'm not saying in every case,
Yeah.
you know,
Well, now what you're saying is there's a distinction between the fraud claim, which I understand.
right. I'm saying there's
and your claims with regard to the appraiser and the umpire.
Yeah, and I'm also saying that there are circumstances where I think it would be proper not to give them a do-over on the appraisal if we get to that point, factually. But I think we're putting the cart before the horse there. So Romanoch, permitted an insurer to bring a declaratory action challenging the integrity of the appraisal based, among other things, on professional relationships between and among the appraiser, umpire, and a contractor with interest in the award, which is very similar to what we have here. There are professional relationships we've alleged among the appraiser, among the umpire, and among the public adjuster, who, as I've shown through his contract, has a stake, a 10% stake in the award. The Mangle Hill case allowed defenses to enforcement of an award based on unfairness, irregularity, or fraud that the insured's appraiser, and these were the words in the court used, that the insured's appraiser was effectively a front for the PA, which is exactly what we've alleged here. That the panel. Okay. I'm sorry.
Never
No,
mind.
that's what the Mangle Hill.
I understand, but go ahead.
I mean, that's what the Mangle Hill court. Those were their words.
But they're talking about a financial front yet, and my concern about your pleading, sir, is that you really haven't alleged anything specific. As you well know, this is a small group of people that does this type of work. Everybody refers to everybody else. That's not going, and pursuant to the case law, that's not going to be a defense here or a cause of action. What might be a defense or a cause of action is if there's a direct financial benefit. And you know, you kind of maybe sort of a little allege that a little bit in one sentence, in one paragraph, but I don't really see it specifically addressed anywhere else.
Well, but that should be sufficient. And I would also say that it's been argued against us by the plaintiff counter defendant that this is just, you know, similar to, you know, a relationship between a party or public adjuster and experts. They referred to the Vernius case. You know, if you hire the same expert over and over again, you know, that's not a disqualifying factor, the argument goes. And I would agree that in the context of litigation, it's not disqualifying if somebody wants to hire the same person over and over and over again, be it counsel, a party, an industry, or whatever. We both have seen it 1,000 times in all the trials and all the depositions. It happens all the time. This, however, is a different situation from that because this is not litigation. This situation is one in which the contract requires an impartial appraiser.
But Mr. Burke.
Yes, ma'am.
Well, never mind.
Okay, so
I mean, what you're saying is we want the contract enforced in this area, but we don't want the contract enforced in another area.
no, we want the-
You know, and when you make those types of allegations that are pleading, they sort of cancel one another out.
I don't know. We want the contract enforced. I mean, I don't think our word, simply because we say it's void makes it void. I think there has to be a judicial determination that it's void. I don't really follow the plaintiff's argument on that point. You know, the contract was in effect at the time of the hurricane. Subsequent to that point, there was a grossly exaggerated claim. We're asking for a declaration based upon a fact finding that it be declared void. So we're not saying that, we're not making an inconsistent argument, and I don't really follow their argument on that point. So what I'm saying is, you know, you have to follow, we all have to follow what the contract says about the appraisal process. And it doesn't, you know, you've mentioned this many times, it doesn't say too much. But what it does say.
Not only that, but quite frankly, it's reversed. The language in the appraisal section requires the appraisers to be competent and impartial, but doesn't say anything about the umpire.
I was afraid you're going to say that.
Yeah, I mean, really, who drafted this? I hope not you guys.
It wasn't me. I have thought about that for many years, ever since they changed this contract. I don't know what to say. It you know, it makes no sense. There is case law like Wenger that requires an umpire to be impartial. I find it very hard.
Well, I think I can imply that from some of
Yes,
the language as well as the case law.
That's where I was going.
But I mean, it is disturbing.
That's where I was going with that. I find it hard to believe that a court of appeal, trial court for that matter, would say, well, the umpire can be corrupt because it doesn't say he has to be impartial, but the appraisers have to be impartial. That's inconsistent with all the case law, because the case law, you know, says, and you've read a lot of it, you've had 1 million of these cases, probably 1,000 insurance cases. The case law says that, you know, where you have a tripartite appraisal, it's the umpire that really counts. But that was changed somewhat by the fact that the appraisal language changed to require the appraisers themselves to be impartial. It didn't used to say that. It used to, as you know, it used to say just, you know, an independent appraiser and a neutral umpire or something like that. And then the case law developed that said, well, the appraisers can be advocates, but the umpire can't. But then the appraisal language changed to require an impartial appraiser, which puts us where we are today. So it's different from an expert. By contract, they have to be impartial. And, you know, we don't have a right to cross-examine them. Like if I was in a trial, I could say, well, Mr. Weaver has hired John Smith 100 times to testify in these cases. You know, how much generally have you derived, blah, 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 blah. I can expose that to a jury in a trial. We can't do that in an appraisal because the fact finders in the appraisal process are the people we're alleging to be not impartial. So that's why I think the rules are quite different in the context of an appraisal. So Mango Hill, you know, we basically parroted, because we felt the evidence supported it, the allegations in Mango Hill. And, you know, we feel that Wenger also would apply. And Wenger, by the way, raises this issue that Mr. Weaver did about the difference between arbitration and appraisal. And that court acknowledged the fact that it was an appraisal and not an arbitration. And they specifically said, well, we don't see any reason why these rules on impartiality should not apply in the context of an appraisal. We've treated appraisals very similarly, and we're going to treat it that way here. The plaintiff points to a statute, suggesting that those are the only limitations on an umpire. 627-70151. By its very language, it applies to proposed umpires in a gatekeeping fashion, and I don't think it really makes any sense at all that it would limit the challenge to an umpire. And I'm not saying, just by way of example, I'm not saying this happened here, but if you take plaintiff's argument to its conclusion, if an umpire took a bribe and we had it on video, we wouldn't be able to set aside the award or disqualify the umpire because it doesn't meet one of those statutory criteria. That couldn't be what that statute means. That makes no sense whatsoever. So in this case, we've pled specifically what's been allowed by these courts. We're pursuing affirmative defenses to the payment of the award based on this misrepresentation and fraud on the grossly exaggerated claim. And we've alleged, it's grounded in the windows. So I think that's specific enough. We've alleged the integrity of the appraisal process. We've already gone over that. And these are all factual determinations by a jury. And then, the mirror image of that is the deck action. If a jury agrees with our contentions, we would ask the court to enter a declaration of rights in the declaratory action. The plaintiff has argued that everything is subsumed in the appraisal, basically, and then you should dismiss it with prejudice. But that's not the law, where the court has exercised her discretion and put this on a dual track approach and had the appraisal proceed first. So these affirmative defenses and deck actions essentially mirror one another. Our deck action is not an action at law for fraud, so we don't have the same level of pleading requirements, although we did plead with...
Correct me if I'm wrong, though. In the affirmative defenses, you did allege an affirmative defense for fraud, based on the failure to include the windows and doors or something along those lines, that whole window and door issue, and quote unquote exaggerated claims. There is that is distinct from these other issues.
Correct.
You don't allege that in your counterclaim because, of course, it's not a counterclaim.
Right. We did allege that with specificity in the affirmative defenses, and basically the deck action is there to allow the court to enter a declaration of rights, and the affirmative defenses provide a vehicle under Chapter 86 to have a jury determine these factual questions. We feel the plaintiff is judicially estopped from making some of the arguments they're making here today, because they went to the Court of Appeal and they literally argued to the Court of Appeal that Your Honor's ruling should be affirmed because the insurance company can pursue their defenses below. Now they're coming before you and saying, well, they can't pursue their affirmative defenses because they're subsumed in the appraisal, which is explicitly contrary, I think, to this case on appeal, and certainly Estero and Leeward Bay. So that's the gist of my argument, but I'd like to briefly address the judicial notice and the third affirmative defense on the windstorm paint exclusion. We've pled that, and the plaintiff has argued that we haven't pled around the exception. I think it would be their burden to show the exception. We have adequately pled that. It's a factual question on whether that applies, because the policy excludes from coverage paint that's damaged by wind, unless like the wall of the building is knocked down. You got to put the wall back up, and then you got to paint the wall when you put the wall back up. So those are all facts that need to be in the record to be able to determine the application of that exclusion. And finally, on the judicial notice issue, I think the court has already expressed some reservations about that, but I don't presume to know how you're going to rule, so I want to address that. They are asking the court to take judicial notice on a document which does not fit within 9202 or 9203 in any way, shape, or form. They're trying to fit it into a catch-all because they say these are facts not subject to dispute because they're capable of accurate and ready determination by resort to sources whose accuracy cannot be questioned. Well, that's an appraisal award in a contested action like that hardly, meets that criteria of an overall catch-all. But in addition to that, what we've pointed out to the court is that the document itself, which they've presented for judicial notice, raises questions on its very face without even going to the competing document that we filed. The document itself says the amount of loss due to wind only is set as outlined in the final award and supporting documentation. That's what their document says. Their document refers to another document as being part of the final award, supporting documentation. They said it. I didn't say it. That's in their award that they want you to take judicial notice of. Well, the award that we filed, that, and I'm saying this, but I think there has to be evidence. This is just my representation of the court. The award that we filed was presented to the appraisers by the umpire, and it included supporting documentation, which broke down these items, including paint and building and all this other stuff in a spreadsheet. We believe that the evidence will show that that was intended to be the actual appraisal award, because in fact, unlike what the plaintiff filed, that has supporting documentation. I don't know if it was just an error on the part of somebody, if it was intentional, if it was an inadvertent. We don't know. There's no record, and there has to be discovery on that. So you can't, well, I shouldn't say you can't, you can do whatever you want, but you shouldn't under 9202, 203, take judicial notice of a document that A, doesn't meet any of the criteria, and B, is not sufficiently.
Here, I can put your money. I'm not taking judicial notice of it at this time.
Right, sure.
Okay, so
and with that, I'll rest.
For one thing, I don't need it to make a ruling in this case.
Okay.
For another thing, there does seem to be some factual issues, whether, again, I realize everybody has a completely polar opposite view of almost everything in this case, because surprise, there's a huge amount of money at stake. But nevertheless, I'm not going to take judicial notice of that. So Kathy, their motion for judicial notice is denied without prejudice. All right, so anything else, Mr. Burke?
Yeah, the last thing I would say is, that I think under the case law is important for me to say, is that while we believe we have sufficiently pled everything, we specifically would ask for leave if the court feels otherwise.
All right. Mr. Weaver, any response?
Yes, Your Honor. Counsel for American Coastal, this is sort of an ongoing theme, continues to complain about a process that it included.
But let's just gear it towards. I'm sorry.
I am. Yep.
Let's just gear it towards what's alleged, what's at issue before the court, etc.
Okay. My only point was that American Coastal controlled at the time of contracting what this process was going to look like. And it made the choices it made when it sold the contract to Pelican Island. The issue of, and this is something that, again, keeps getting, I think, misstated, the issue of an assignment to Key's claims. Mr. Burke accurately read to you the portion of the contract that uses the word assignment. It's an assignment of right of payment. It's not an assignment of the claim. And that is a key distinction. If you look at the Romanot case, for example, there was a water mitigation company involved in that case.
I don't think that, maybe that's an issue, but I don't know that.
Well, the argument, Your Honor, the implication, and it's never been directly argued, but the implication is that by virtue of an assignment of the claim
to Key,
you treat Key's claims and the insured the same.
Mm-hmm.
And there's no support for that, either in the contract between Key's claims or the case law. Again, the American Coastal has yet to explain at any time.
Okay, let me back you up just a minute, because maybe I'm misunderstanding their point as well as yours. But my understanding of their point was that because the public adjuster has an assignment of a certain amount of money for his fee, that the implication is, I'm not sure this is alleged, but the implication is that the public adjuster will in some way share that 10% fee with the appraiser and or the umpire. That was my understanding of the implication. I don't actually think that that's specifically alleged, but nevertheless, that was my, is there something I'm missing from your perspective?
So that was not the take I had on it, but
Okay.
I do agree with you that seems to be necessary. In other words,
Oh,
the
I see what you're
allegation.
saying. You're saying because Keys has a 10% assignment, they're trying to conflate an owner of the property such
Yes.
that would disqualify the appraiser and the umpire, or at least the appraiser, because then they would have a relationship with an owner,
Correct.
which would of course
Correct.
disqualify him pursuant to the statute.
And
okay.
would fall within these other cases that we've been
I
talking
gotcha.
about,
I
direct
gotcha.
financial
Okay.
relationships.
I understand. Go ahead.
My take on that point was just that. I agree with you. They have not alleged what's essentially a kickback arrangement between Keys and Middleton or Keys and Woodard. There's, I think, good reason for that because they have no basis to allege it. But that is what is missing, and that is what they cannot allege on the partiality issue. Again, Winger, I'm not going to belabor this too much. If you read Winger, there is a history of the umpire's relationship with State Farm. The umpire actually said, and this is in the opinion, that he had been retained during the same year that he was appointed as an appraiser, but he didn't know how much money he was going to make from State Farm. In other words, he was going to get something during that time, but he didn't know how much. So I think Mr. Burke's point about Winger is slightly overstated. Again, the issue of needing a direct financial relationship between the insured, that's what all the cases talk about. It's either that or it's a relationship with a party to the contract, either the insurer or the insured itself. So Alvarez, for example, is that situation. Winger is that situation. Some of the other cases we discussed are that situation. This is where I'm going back to the issue of the assignment. There's no allegation that those relationships exist between Pelican Isle.
Excuse me. You guys didn't notice I got kicked out of the meeting.
Okay, well, yeah, I was paying attention to what Mr. Weaver was saying. So how did you get kicked out? When did you get kicked out of the meeting? What was the last thing you recorded?
One moment, please. My device actually crashed is why. Going back. Such that would disqualify the appraiser and the umpire, or at least the
Okay, who was speaking when you got kicked out?
You were, Your Honor. And I'm very sorry about the issue.
Okay, well, but were we in the middle of Mr. Weaver's response, or were we in the middle of Mr. Burke's response?
Mr. Weaver was speaking with you.
Okay, so
if you just want to go back about 2 minutes,
okay.
I really didn't miss much. I came
right.
back.
So Mr. Weaver, up to you, whatever it is you want to put on the record or not.
Yeah, I'll do my best, Your Honor. I don't exactly recall where we were.
Okay, well, I think if you go back, I think you and I were clarifying what you thought the issue was with regard to the owner / party relationship, and you were then, I guess, expounding on that.
Okay, so again, I think the distinction that has to be drawn is the distinction between assignment of payment under the contract with Keys Claims and assignment of the claim. I think what keeps being suggested by American Coastal is that those are one and the same, and that they are not. To the extent that you can treat Keys Claims and Pelican Isle as one, I don't think that's reflected in their pleading or the contract between Keys Claims and Pelican Isle. That was the point I was trying to make.
Okay.
Thank you.
Again, on the issue of the Winger case, there's discussion in the Winger case about the umpire's ongoing relationship with the insurance company, including in the year in which he was appointed as the umpire. And the issue about arbitration and appraisal, that was an argument that State Farm didn't preserve below in the Winger case. And the court actually disagreed with State Farm's position there. So again, that's counter to the Alvarez case that was subsequently decided by the Florida Supreme Court. And with that, Your Honor, we just reiterate our request for dismissal with prejudice. Thank you.
All right, I'm going to make a ruling and I'm going to make some findings of fact. Mr. Weavy, you're going to be responsible for drafting the order, so I'm sure you can have the court reporter type it up, but pay attention. First of all, I'm going to reserve to make any findings or conclusions of law. I won't really be findings of fact, it'll be more conclusions of law that are consistent with the argument and the filings that I might forget. I do try to make findings, but sometimes I think of things as I'm reviewing your orders, and I want to have the ability to do that. So first of all, I'm going to make some findings. I find, as Mr. Burke and I discussed, that the language of the policy is unfortunately sort of, I would say, backwards. Let me just go to it, hold on. It requires that the appraiser be competent and impartial, but does not require the umpire to be competent and impartial. However, based on the fact that, number one, that each party is to pick its own appraiser, I am finding that my interpretation is that this implies that each party is going to pick somebody they think is going to be more favorable to them. Otherwise, why have each party pick one? Secondly, that the language competent and impartial with regard to the appraiser means that the appraiser cannot have a direct financial interest in the case upon which he or she is the appraiser. And that's consistent with statutory and case law. Furthermore, with regard to the umpire, well, as I've noted, there is no requirement that the umpire be competent or impartial. Nevertheless, because the contract does provide that the appraisers either pick the umpire or a court appoints the umpire, and because of case law and statutory law, that it's clear that the umpire is intended to be a mitigating factor, if not impartial, and that these three people are functioning as a panel. However, they function in different ways. All right, let me just cross things off here. So that's my interpretation of the contract. For next, with regard to, again, my interpretation is that based on both of your pleadings, what will result here, see, this is contractual provision. I mean, I don't have a problem with you guys just going to court, but you all contracted to go through the appraisal process. And not only that, but you both have filed declaratory judgment actions asking that the appraisal process be either enforced or not enforced, at least this last appraisal process. Therefore, what's going to happen with this is that it's going to go back to appraisal. So it's not going to invalidate the contract, but it's going to go back to appraisal. Next, I'm finding that the public adjusters, that the assignment of 10% as a fee to the public adjuster does not make the public adjuster an owner or a party in this action, such that a recommendation or of the appraiser by the public adjuster does not create a relationship between the appraiser and an owner slash party. All right. So with regard to what's in front of me, I've already ruled on the motion for judicial notice. With regard to the affirmative defenses, I'm striking the affirmative defense 1 without prejudice. I'm finding that you really haven't made an allegation with regard to the direct financial relationship between the appraiser and the umpire and the public adjuster. You alleged, as I said in paragraph 3, you sort of conflated the two, and that really just does not make it clear. That's not, hold on. No, and that's in the counterclaim even. So you conflated the two, like, I think that something along the lines of the appraiser and Keys receiving the fee, but you didn't really say, it makes it look like you've just sort of tagged the appraiser on there, and it may be that Keys is really receiving the fee, not the appraiser. So you need to make that more specific. Is the appraiser, are you alleging that the appraiser has a direct financial interest in this proceeding? A referral, a recommendation, not a referral, but a recommendation is not enough legally to subvert this process. I'm also striking and not allowing leave to amend on the issue of how the process was conducted. In regard to affirmative defense number 2, I'm striking everything except the allegations of fraud with regard to the windows and doors. With regard to affirmative defense number 3, I'm striking with leave to amend with regard to exclusions. Again, I think there needs to be a little bit more detail in there. It doesn't have to be a lot, but it has to be a little bit more as to why the successive provisions that would obviate the exclusionary clause don't apply in this case. On the motion to dismiss the counterclaim, all right. I'm not dismissing the allegations with regard to the windows and doors and any allegations of exaggerated claims. I think if the window and door issue is your only example of the exaggerated claim, I mean, remember, we are a fact pleading state, but they don't have to allege every fact that exists in the known universe. They have to say, I mean, if, for example, they said, the plaintiff exaggerated their claims, including but not limited to, the windows and doors, I think that's sufficient. There may be other instances where they allege there was an exaggeration of claims, but they don't have to allege each and every one of them. My impression from reading this is that they allege exaggeration in the windows and doors, and they allege exaggeration somewhere else, which they don't state. So I'm not dismissing it, but I'm going to give you leave to tighten that up if you need to. I don't know whether you need to or not, because I don't know if there's other instances that you might want to allege, or that it just needs to be connected more tightly to your example of windows and doors. Okay. With regard to the issues of the appraiser and the umpire, again, I'm going to dismiss with leave to amend, but you have to allege direct financial interest in the property. You have to allege that Keys is given some of the fee to the appraiser and or the umpire. Okay. And then I am dismissing with prejudice the allegations with regard to the abusive process. I agree that does not state a cause of action based on the case law.
I'm sorry, what, I didn't understand the last ruling you're on.
That's consistent with my striking of the affirmative defense. I dismiss with prejudice the portions that you're alleging were abuse of process. What they considered, what they didn't consider, none of that is a cause of action.
I understand.
Okay, now, those are my rulings. Did I rule on everything, Mr. Weaver?
I believe so, Your Honor. Thank you. Oh,
In addition, go ahead.
I actually think the issue of post-loss condition compliance may be left outstanding.
Did anybody address that?
We did, Your Honor. It was in our motion to dismiss. This relates to the allegations about failing to have certain people sit for examinations under oath, et cetera.
Judge, we said we're not proceeding with that, and when we amend, we're not going to include that.
Okay, that's fine.
Accepted.
So they've dropped it. Okay.
Understood.
All right. So moving on, though, I am going to enter an order that you go all sit down and mediate this. And I'm going to tell you why. This is a mess.
Judge,
And
if I can
ahead.
interrupt, we have mediation scheduled for June 1st.
Excellent. Okay. Does it include the umpire? It needs to include the umpire. I mean, I've allowed him to intervene. So, I mean, for whatever purpose he wants to be a part of it. So, I mean, or his counsel, but he's got to be somewhat a part of it because I've allowed him to intervene.
I mean, I don't have an objection to that. The only problem may be the scheduling. We got a mediator that's has a very tight schedule, and this isn't 2 weeks. But certainly, I mean, I have no objection. I don't know if Mr. Weaver
I can't imagine that they'd really object that hard because
Yeah,
getting paid. But because here's what I see is going to happen down the road is, you know, obviously there's a lot of money at stake here. I understand that everybody needs to litigate vigorously and represent their clients vigorously. But I've already heard from both sides some things that I think might cause you problems going down the road. For one thing, again, as I've pointed out, and Mr. Burke even acknowledged, you know, it was known at the time that the appraiser was hired that he was a recommendation from the public adjuster. Number two, I've heard from not just Mr. Weaver, but I also heard some confirming representations. It wasn't testimony, it was representations, that American Coastal or the Council for American Coastal or somebody for American Coastal knew or should have known about your allegations before the appraisal award came down, and that you waited until after the appraisal award to bring these issues to the fore. I don't know whether you did or not. I'm not making a ruling that. All I'm saying is that just opens everybody, you know, and then of course, Mr. Burke may allege that Mr. Weaver knew some stuff and didn't disclose it and so on and so forth. So that just opens all of you guys up to a number of problems. There may be a bad faith cause of action coming down. You guys all may get disqualified on this case. So, you know, because all of a sudden you are fact witnesses to some very crucial issues. And again, then we're just, you know, then we got more fees, we got more, all kinds of things. And it's not good for anybody, including the insurance company. So my point here is I think mediation is important for you guys. You've already got it scheduled. That's great. But there's reasons to try to settle this case. And then, you know, I would also take a look at, you know, what's happening litigation-wise. I don't know that any of these big cases have been yet litigated before the courts or tried before the courts. Certainly a lot of residential IRMA cases have been, and that's not really the same. But this isn't the first hurricane we've had, and this isn't the first big condo case we've had. I've forgotten, maybe it was Wilma. I think it might've been Wilma. We had some big condo cases, you know, not a lot, but a few. So you all might want to look at those too. And
we tried one in front of Judge Schoonover.
Okay. Yep. So anyways, but it's not my place to tell you what I think juries do, because I honestly don't understand what juries do sometimes. So, you know, but you guys are the experts in jury science. And so you can, you know, look at those things and advise your clients. But just remember, going to court in front of anybody, a judge or a jury, is not a for sure thing, even though it seems really clear to you. So it looks different when you have to make the decision.
Can I ask you a question, Judge?
Anything else I can help you all with?
Yes, I have a question. We have this mediation scheduled for June 1st.
Yep.
The court has told us, and we don't disagree, that it would be useful to have the umpire present.
Yep.
Since the umpire and his counsel were not part of our scheduling, what do we do if they're not available?
I think,
here's
Mr. Har, are you available June 1st?
I actually just looked, and that week is June 1st is the day I'm available.
Excellent. Problem solved.
I will reach out to Mr. Woodard and make sure that he will make himself available. I assume our role is going to be somewhat limited, so
Yes. Yes, your role is
make
limited.
that happen on June 1st to the extent that you guys need us there.
Okay, yeah. I mean, obviously, you don't get involved in sort of the larger issues, but because I have granted you leave to intervene, I feel that you have a right to be there. And things may happen that you might want to have some input into that affects your client's fee. You know, similar to what happens when an attorney takes over a case and doesn't protect the prior attorney's fees, and you know they go off merrily and settle a case, and then the prior attorney that did all the work says, "Hey, what about my fee?" So that's the scenario I'm sort of thinking of. All right, so Mr. Weaver, you can prepare the orders.
Yes, Your Honor. Happy to do so.
All right, and Mr. Har, you're preparing your orders. All right, everybody. Thank you very much. Have a good day.